professional a short period of time to sit the exam, pass it, present the credential, because in order to be in compliance with the ordinance and actually finalize the hire, you'd have to have it. But, I'm looking to the solicitor to see if that meets legal muster, but
I think if the ordinance says required,
Then it's required.
Well, that's why I'm saying, why do we need the language required? We could have a provision in here that would make it
I think if you want it
mandatory
required,
through a
I think if
probation
you,
period.
my suggestion is if you want it required, it should say, should be required by the end of the probation period, or should be required within 6 months of hiring. I think that would be, or within 1 year of hiring, if you want to allow,
Depending on the
depends on the
timing.
cycle of when the
Yeah.
exam, because you actually have to apply like 2 months ahead of time and so forth. I understand the administrator saying it. I mean, we have people with positions sometimes now with DPW, with, and other things, commercial driver's license stuff, and we're not requiring that they have it immediately, but it's clear they have to get it. But I think as long as you have the opportunity now, you should clarify it now, so that, seeing we might have people who've said they'll already challenge it, you wouldn't want to have it say required, hire someone, give them time to do it, and give somebody an opportunity to challenge it. So if you're gonna make that, if you want it to be required at the time of hiring, then say that. If you want it to be required within a certain period of time, say it.
Okay, any further
I just
discussion?
have one quick comment, and, I'm sort of sympathetic to Andy's comment earlier about the professional, sort of governing professional organizations, because I know a number of planners who are certified, and I know a number of planners who are not certified, and, unfortunately, I think that the AICP certification maybe gives false sense of security to some, in some instances, because I think the lousy planners that are AICP certified are worse than the good ones that aren't. It doesn't really, you know what I mean? It doesn't guarantee a successful a planner. So that's just my 2 cents. I'm not entirely certain it's required, but
I think the certification, certainly, if there's any lawsuits, it would hold up better in court if the planner is certified rather than not certified. I move the question.
well, we're having a conversation, so
Well,
I
actually,
respectfully.
we're in discussion.
Well,
I'm just saying.
that's fine. Do whatever you want. I don't care. I'm not going to convince anybody who's not.
Joan, are you open to considering amending your motion to consider?
I move the question.
So you need to either, if there is no debate, you don't have to vote on it. If some of you want to keep discussing it, then you should have a vote on the motion to move the question.
Right. So we
On
have
cutting off debate, essentially. That's
we
what
have
you're-
a motion and a second to move the question, so.
You have to have a motion to move the question.
No, we take a vote on the motion.
No, if she's moving the question, she wants essentially cutting off debate. But if there's, I mean, your general thing is if no one is objecting to it, then you can just go ahead and have the vote. But that's what I'm trying to say. If people do still want to discuss it, then you should vote on that very question first of moving the question, basically cutting off debate. That's what you're voting on.
So we need a motion to move.
She has made a motion to call the question.
Okay. So we need a second.
I don't believe a motion to move the question needs a second.
I don't think it
I don't
does
think so
either. It
either.
doesn't
It
need a
needs
second.
a
no.
vote.
I think it just needs a vote. So
And
we-
if the vote is not in favor of the motion, then another motion can be made to modify it.
Yes.
But I'm moving the question
Okay.
on
So,
my motion.
okay, all right.
Are we voting on her move to move the question, or are we voting on the original motion?
You're voting on the moving the question. You're voting on cutting off debate.
To make sure everybody understands.
No. You're voting on the motion.
We're not
No,
voting
we're
on the
voting
motion.
on
You
whether or
have,
not we're going to move it.
You're cutting,
It's
you're,
not being-
to move the motion, you are ending discussion.
Discussion.
You're not voting on the motion, you are
And
ending discussion.
only in the instance that we voluntarily give up our desire to discuss further is the original question voted on.
The purpose of moving the question is to stop debate and to vote on the motion. It's not a vote on whether to vote on the motion, it's to vote on the motion.
So as you, just so I
Okay.
understand this, so you're saying that this vote that we're making at this point not only ends discussion, we've made a determination?
It ends
on the merits?
it ends discussion on my motion. Another person can make another motion if my motion fails.
But don't we
Robert
have to have a
rules.
motion to move the question?
No,
She's correct.
no. No.
So you could, I'm sorry, so just theoretically, you can make a motion, deny anyone access to a debate, and then just have the question voted on?
I don't believe
That's
that. I don't
absurd.
have my copy, I don't have my Robert's rules with me. I wasn't anticipating that kind of meeting. My understanding is that if, yeah, because otherwise, one counselor,
I think some
could
debate has
always,
to take place before you can move a question.
well, but then one counselor could always cut off debate.
Yeah.
So I think, I agree with her that I don't think there's a second required, but I think there needs to be a vote now on moving the question before you actually vote on it. And so it's essentially, moving the question is essentially cutting off debate.
That's how I thought.
And that motion, although we're obviously, if we were going to be specific, we're discussing point of order. That motion itself is not debatable, whether you want to continue. But it is a motion and a vote, whether you are cutting off debate or not. And then you would get to the regular question.
You do need, I've always gotten a second for moving the motion. When I used to run a meeting, but things have changed, I guess. I don't know.
I'm not sure about that.
Oh, I'm sorry. Robert's Rules, section, let's see, 16, close debate, move the motion. Let's see, I move the previous question. Is there second required? Yes. Is there debate? No. Can you amend? No. You need a two-thirds majority vote to sustain.
Right, to move it.
All right, so we need a second.
Right, you need a second, and then you need two-thirds to move the vote.
Do we have a second?
Second.
All right, we have a motion and a second. All those in favor? Opposed? Is that two-thirds?
Continue.
Okay, so now we go back to the original motion where we had a motion and a second. We are still in discussion.
And the motion that you have pending is a motion to amend,
Amend
to change required.
the audience from desired to required.
And all I wanted was a clarification. There was a statement made that an individual who held an AICP certification would be held in higher authority in a court of law, and I wanted a clarification if that were the case. That's all I wanted to know.
And is that from me? I take it you're looking for the clarification.
Any of the lawyers.
Any of the lawyers.
I won't put the others on the spot. It is possible, but it's unlikely that that sort of circumstance, if a planner is going to be providing their opinion, for example, the planning board staff comments, then it is considered to be expert testimony. But that can just as easily be based on their experience and education as well as the certification. Would it be one more little thing? Yes. Would it be significant? I think hardly likely. If there's one planner that's testifying who has the certification and one that's not, I don't think that's what tips the scales.
Okay, thank you.
Okay, anything else from the council? All right, I'm just going to add my 2 cents. I think that the AICP certification should be required, but I think it should be after a period of time if they don't already have it. So that whatever the probationary period is, that it should be at the end of that probationary period, because up until then, you can, whether they had it or not, you can ask them to leave. So I would humbly request if you would amend your motion to give a time period for certification be required, but if they didn't have it, that they get it within a certain time period.
I withdraw my motion.
Okay? Then I will entertain Okay.
Draw a second.
Okay, so the motion has been withdrawn. I will entertain a new motion to add the AICP is required after a set time as determined, because a lot of times, depending on the time of year, if they're hired and they come in right after the thing has been, the test is given, or if they're mid, whatever, so you really don't know what the timing, so if it would be after a probationary period or 6 months or...
I think you're safe saying 6 months, Mr. President. I really do. As a general matter, all of the job descriptions I've written have included additional educational or experiential requirements for the jobs that we're hiring. I think raising the professionalism of the people who work here is an important objective overall. And so I support the idea of an AICP certification. 6 months seems to me to be a very reasonable period of time for somebody who meets the experience and education requirements to apply for the job in the first place to sit the exam.
Okay, so that is the motion that I will entertain, that AICP required within 6 months, if not already obtained.
I would just say within 6 months of date of hire.
Right.
If I can add my comment, it sounds perfectly reasonable, but you haven't begun the negotiations with a candidate yet. That's why my suggestion would be, is required by the end of the probationary period set by the contract with the employee. You may have an applicant who says, gee, I need 8 months, I need 7 months, I need 9 months. I don't know, and you haven't even begun the negotiations, and we haven't picked the applicant yet. So I'd leave a little leeway instead of saying just 6 months, that's it. 6 months in 1 day, that's no good. 6 months is great. I wouldn't tie it down like that, but that's...
And I mean, it hedges in the event that the AICP decides to alter their testing schedule, and if it doesn't meet within the 6-month period, that would buy us a little bit of flexibility.
You could always change it. I just think as a policymaking body, you certainly have the authority to set these minimum requirements so they're not negotiated in a contract.
Right, because, I mean, and I agree in some sense, but I think what could happen is you have a candidate who comes in who checks all the correct boxes, and for whatever reason, they want to wait a year. You know, so now you're saying, well, gee, we wanted 6 months or 8 months, now it's a year. Does it become a year and a half? You know, so I think a set requirement, and again, if there are extenuating circumstances, it is within that 6-month period that no one is giving the certification test. I mean, how can you make them, you know, comply with something that they can't do until it's offered?
You won me.
You know,
You're right.
If I could, I would just add one more note with the certification, is that it does take a period of time for the test results to come in after the test is given. So you may want to consider that when you're setting your time period.
What if they take it?
Because I'm sure, that, you know, they have to
Well,
pass
they
the
have
test
to,
and certification.
right, but they have to
Yeah.
take it within the 6 months, and then we'll deal with if they fail or
Yeah,
not
if they fail or
later.
not, you know, whatever.
But they have to take it within those 6
Yeah.
months. So I understand we won't know the results, but at least they've attempted.
Yeah, they've attempted to meet the requirement,
Right,
and whether or
right.
not, we
But
wouldn't
then-
know
but then
until...
That's a whole
Yeah.
other issue. We'll have to deal with if they fail it.
Okay, so, I don't recall now, do we have a motion and a second on that?
I don't think so. We need a motion.
I'll make a motion that we amend, just want to keep this moving along here, section 59-4, town planner qualifications, paragraph B, to state an American Institute of Certified Planners certification, parens AICP, is required within 6 months of date of hire.
Second.
Second.
Any discussion? Seeing none? All those in favor? Opposed? 5-2.
Yes.
Okay. All right, okay, and, all right.
I'd like to discuss item, section 59-5, Planning Department duties, item C, aid and assist Planning Board with the rewriting of zoning ordinances. I'd like to add to that, and provide documentation of all potential impacts to the private property rights of property owners. And provide documentation of all potential impacts to the private property rights of property owners.
Just for clarification, Mr. Shep, you mean any resident in the town?
If they're making changes to the zoning ordinance, I want it to be clear that they have to provide documentation of how that change will impact the private property rights of property owners.
Is that already dictated by, I don't know, I'm just asking the question. Is that already dictated that if there are changes to zoning?
Well, there has to be a hearing.
There are notice requirements in the law, including notice requirements if a change is being made to a specific area, to a specific map of people within that area and within a radius around them. That's what's required. All zoning impacts property rights. Going back to Magna Carta, it's imposition of the sovereign's rights on the people versus the people's rights.
Those are notice requirements, though, but I think what this point goes to, and I guess I'll signal that I think it's a good idea, is individuals revising such complex legislative systems should take a very balanced approach and show both upside and downside to all parties affected. Now, this is a great level of detail to put into the ordinance, but it's a fair point that we don't want the planner advocating for specific changes. We want the planner saying, this is an area you can consider for change, this is the benefit of doing it, this is the negative of doing it, and let the policymaking body decide.
So mechanically, that would look like, say, the planning board has a project that the planner is assisting with in rewriting a zoning ordinance. The planner would be tasked with setting out the benefits and detriments of those changes, sort of to provide to the planning board in decision-making. That kind of came out a little bit clumpy, but...
Yeah, I think I know what you mean. I think I can give you an example.
Okay.
So if you're going to rezone portions of Main Road, for instance, and you would be more or less creating, I would expect the planner to say, by doing that, you're going to create 10 pre-existing non-conforming uses. And therefore, you would be limiting those 10 people to not being able to expand their building. Just go through it and be very explicit about what the ramifications would be. I would expect that of any professional, so putting it in the ordinance is a choice that you guys can make, but as far as what the expectations would be, it's a comfort zone. Cost-benefit analysis is an important part of a lot of things we do.
I'm sorry, what was the language again you were going to...
To add, and provide documentation of all potential impacts to the private property rights of property owners.
My concern was, I guess I was interpreting that too broadly, or maybe I'm not. If we have an issue relating to zoning, let's say in the north end of Tiverton, I can see how that could impact South Tiverton. I really could. It might impact, if nothing else, their tax bill. It might impact on subsequent development in other areas of the town. I think that's it just seems to be such an overwhelming responsibility. You could believe on its face that you're impacting a zoning area to help North Tiverton, and you may, in fact, I guess an argument could be made that you're somehow impacting on residents, taxpayers on Boogamarsh Road. Well, I could make that argument.
I don't know that you'd be
Joan, how
impacting
does,
their property rights.
can you help me understand how your language, and I get where you're going with the language, how that's different than the
what they do now.
noticing requirements?
Right. Difference is that this is, item C, is for rewriting the zoning ordinances.
Okay.
And when you do a rewrite, obviously, there's a lot more complex changes and a lot more detail required. And I think this raises this to the level that it requires that documentation in writing that says you have to provide documentation to the potential impacts, all the potential impacts to the property rights of property owners. I just want it to be explicit. I think it's needed to be there.
So that doesn't, if I'm understanding you correctly, that, I get where you're going, like it's a thorough documentation of any and all kind of risks and impacts and all of that sort of thing, that does not necessarily translate into noticing the entire
Correct.
town by certified letter or something like that.
It could be in the case of Main Road to Main Street project. We should have been given the documentation to say how much of the general commercial space area was being changed from general commercial to residential. That's part of documentation that's in the comp plan. We were taking a guess. We don't have that information. So we don't know the impact, truly, of what was identified as general commercial and the change from that district to the 3 sub-districts where some of those properties were changed to residential. So it would give you a higher level of how much percentage have we lost of general commercial by making this change. So we didn't have complete documentation. And this is just to specify that complete documentation on the impacts.
Okay.
It's different from noticing those property owners by law. There's separate law that requires notification to property owners.
Anything else from the council? Was that in the form of a motion, Jen?
I'll make that as a motion.
I'll second.
Any further discussion? Where's Denise?
She's otherwise occupied.
Just for fairness, I would wait until she returns so that everyone has a chance to vote.
Can I move on to
Yep.
another item? Section 59-5J, where it says, monitor funding opportunities and prepare grant applications available through the Rhode Island State Office of Planning and other appropriate sources. I'm concerned about this one in that, in the past, we have a planner that went out for funding without the town council being aware of the grant application and its impact to the financial budget before it was applied and approved. We were blindsided by that, and basically blindsided with all of its ramifications to budget and to just the whole process. So
What was that? Refresh our memory, I'm sorry. Is not ringing a bell.
on the challenge grant, we didn't know that the challenge grant was even an item until it was approved, and Mr. Spencer came to the council for funding,
For a match?
match funding,
Okay.
after the grant was already approved. So on this item, I believe there should be some wording that,
Upon approval of the council or something like that.
correct.
Would that be the council or the town administrator? I guess it's a question of how deep in the weeds you want to get.
All I know is we ended up, the town council had to approve a budget for it,
Yeah.
and we were definitely blindsided.
Any grant large enough that has this sort of matching requirement, I could never transfer on my own authority anyway. It would have to be done before the council.
Okay, before we make a motion on that, we're going to go back to item C. And Joan made a motion, seconded, to add documentation, and provide documentation of all potential impact, private
To private property rights of property owners.
Of property owners. Okay, so we had a motion and a second. All those in favor? Aye. Opposed? 5-2. Okay, all right, now we'll go on to item J, and just adding upon approval of the council. I'll entertain a motion on that.
So moved.
Where would the wording be, though? If I can suggest this wording, Mrs. Shabbat, monitoring funding opportunities and with the approval of the town council. Because I would expect you'd monitor, but the approval would only be for the actual application.
Agree.
Okay.
Yeah, because, and then we would know whether or not they have matching
Exactly.
funds or not.
You know, it's,
Did you make a motion?
Oh.
Second.
Okay, we have a motion and second. Any discussion?
Just to be clear, monitor funding opportunities and with approval of the town council, prepare grant applications.
Applications available through blah, blah, blah. Okay? All those in favor?
Aye.
Opposed? Motion carries. Anything else?
We had the couple of suggested edits by the town solicitor, which were with regards to the, yep, section 59-3. Andy, keep me honest here. Your recommendation was to replace the entire current paragraph within section 59-3 with the sentence, "The town planner should also be the administrative officer."
Shall.
Shall.
Is that a motion?
Yeah.
So moved.
Second.
Okay, we have motion and second. Any further discussion? Seeing none, all those in favor?
Aye.
Opposed? Motion carries. Okay, I think
And then
yeah, there was somewhere else.
there was the second, so in section 59-6, authority and reporting, we would strike the second sentence in its entirety.
The third sentence.
I'm
Third.
sorry, yes, the third sentence. The periods are blurring at this hour. And with regards to the first sentence, we would modify it to read, "The town planner shall report to the planning board and the town administrator."
Correct.
Second.
Okay, we have a motion and second. Any further discussion? Seeing none, all those in favor?
Aye.
Motion carries. Okay, are there any other
Joan
changes?
opposed.
Yeah, are there any other changes, additions, amendments? Okay, if not, I will entertain a motion on the ordinance number 2014.
I move that we adopt the amendments to the Code of Ordinances. I'm sorry. Sorry. I move that we adopt the ordinance as amended regarding the planning department.
Okay, we have a motion.
Second.
And a second. Any discussion?
Discussion. I just want to make my final comments here. I believe that the AICP certification is required. I agree with the Budget Committee that they voted $20,000 for a part-time planner or consultant. It was mentioned that the planner works on a project-oriented basis, and based upon that, a consultant is actually a preferable method when you work on a project basis. I do believe we need a planner. I believe it needs to be either part-time or consultant basis, and on that, I will be voting no on this ordinance.
I just have a couple comments to make also. I kind of agree with Denise. I'm not sure if we need an ordinance to have a planner. But some of you may know, my mother is on the planning board. She was probably one of the 3 who voted for the planner.
Budget.
Budget.
I'm sorry, budget committee. What time is it?
I'm gonna tell you,
11
She
o'clock.
doesn't know she's on the planning board.
She does now. Sally will tell her later. But some people might think that she might speak for me here, but that's not the case. If anyone actually knows me or my relationship with my mother, they would know otherwise. But well, my comments for the plan, I'll keep them very brief here. Is I've always heard what's happened in the past with the past planner, what's happened, oh, we did this when he did that, and it was horrible, and we can't have this anymore. I agree with that. We can't have it anymore. And my vision of what a planner would be is the fact that we are trying to reduce our taxes on the residents. And I think we need someone professionally capable to help us do that, so we can take some of the tax burden off the residents and increase our commercial tax base. And I grew up in this town. I've lived in this town going almost 30 years. I'm looking for a house in this town. Believe me, I don't want to raise my taxes any more than I raise anyone else's taxes. Because everyone that thinks sometimes forgets that we also live in this town. And we also have to pay taxes ourselves. That being said, I think there is a good use for a planner in this town. And looking forward to the future, if we don't help ourselves grow, then you're right, Ed. What's going to happen? Because let me tell you something. I'm looking for houses, not just in Tiverton. I'm also curious. Where do communities have for houses in comparable price ranges? Where they pay for taxes? Let me tell you something. Tiverton is not any cheaper tax-wise than some of the communities in the state. I think the only one they bring to us within Rhode Island is Little Compton. But their demographic is far different than Tiverton's and what they offer for services, for number one.
And the valuation.
Right.
People always link it to the tax rate, and they forget that a $200,000 home here is possibly a $400,000 home in another community.
And that's what it is in Little Compton, by the way.
Yeah, I know.
I was curious at Lincoln, because Lincoln has Twin River. They have a very large commercial tax base. It's like 60-40. There's a split roughly, I think is the case. And their taxes are higher than Tiverton's on this, a comparable priced home. So I was like, what the heck is that? So with that said, there are people who are hurting this community. There's people hurting in almost every community. And I'm just trying to make the best decision to help those people going forward and help bring business into town to take some of the burden off of their backs. And that's the reason why I would support a planner. Not necessarily what we had in the past, but going forward, someone who actually be doing some of the things, and I'm actually glad we're defining some of these tasks. I just don't know if they need to be in an ordinance.
And you already had a turn, didn't you? No, I'm kidding. Go ahead.
I've heard people say, we only need a part-time planner, or we can hire consultants. Well, and again, the issues that are going on today are only going to grow. And if we were to hire a consultant for every issue that we've got going on regarding planning in this town, believe me, $20,000 won't cover it. And if we want this town to move forward, we have to, absolutely have to, get a full-time planner in this town. I live here, I own a house here, I pay taxes here like everybody else, and I don't want my taxes to go up. But let me tell you, I can guarantee that unless we have the foresight and decide that we're going to bring in business and work hard and plan correctly, rather than jumping from opportunity to opportunity and then don't have anybody to follow through so it falls apart, then we're going to be saddled with taxes from now until doomsday that will continue to increase. And, I'd rather pay a little now and hopefully reduce our taxes in the future than have to sit here 5 years from now saying, gee, we should have and we didn't.
I just want to reiterate what I said. I don't think we need an ordinance. I think this town council has the authority to hire a planner, and I think they can hire a planner without increasing taxes. I think this ordinance will open up a whole nother can of worms and possible lawsuits, which we are trying to avoid. So I do believe in a planner, but I will vote no for this ordinance because I really believe it's not needed.
Anyone else? Okay, I agree. I firmly believe that this council has always had the authority to hire a planner. It has been our policy, and I think that we should just move forward as a council, and that's our policy. I do think that the issues and things that came up under should be incorporated into whether it's the job description or the advertisement of such position. But again, as an ordinance itself, I don't really think we need one, but I do think that we do need a planner, and I would, state that all these changes and additions be part of a job description and/or the advertisement of said planner. That's my
Right,
opinion.
I'd also like to add, the townspeople did vote for a town planner. The money, the line item is there. So the townspeople did vote for a town planner.
Mr. Lambert,
question, no.
might I indulge you to read, I don't have my charter with me, might I indulge you to read the brief section you read?
Okay, I think I can find it. Okay. The sections that I read under section 407 were as follows. Among its powers and duties, the council shall, 1, serve as the policy-making body of the town. 2, create, change, and abolish town offices, departments, and committees not established by this charter.
Thank you.
Anything else from the council? Okay. Madam Clerk, just so everyone is clear, would you please read the motion?
It was to move to adopt the ordinance as amended regarding the planning department. It was made by the Deere and seconded by the Sherlock.
Okay. All right, we have a motion and a second. Any further discussion? Okay, all those in favor? Opposed? 5-2.
Motion doesn't carry.
The motion does not carry. Okay, and again, I state that I believe that we have the authority to hire a planner, and I think
Without
we
this
should-
ordinance.
Without this ordinance, and I think we should move forward in doing such.
Mr. President, can we make a motion to accept the amended changes to that proposal as a job description?
Absolutely.
Second,
We have a motion and a second. Any discussion?
as a suggestion for a job description. This is the job description.
Adopt the changes to a job description.
We can do that.
No, you don't have any job description on you.
All right,
Well, you
well,
voted against the motion
okay.
For an ordinance.
for the ordinance.
For the ordinance.
There's no description, there's nothing on the agenda about job description or
All right.
anything like that.
All right, we'll add,
Could we suggest that the town administrator make up a job description
yes.
and put on the next agenda for acceptance? Yeah, okay. All right, Andy, I know we're tired.
Okay, yeah, it's now 11 o'clock.
You know, Andy, we have half of
I
it.
am, I agree.
And Andy, I just want to say, you did not keep your promise to Amy.
I know. Well, in fact, I've been waiting for the solicitor's item to introduce her, so if I could just, well, I'm going to let her go home now, so, just so you, this is Amy Goins, who, we'd sent a memo around before, she's a new associate with our office. She's not that, she's been working for over a month with us. She's worked on a lot of Tiverton stuff already, and we'll be working on more. And so I wanted her to get a feel for you, which I think she's gotten over the last 4 hours. And now you've gotten to put a face with the name, and I'm sure you'll be seeing her again over time. So,
Welcome.
Mr. Tice, I did have one question, though. If we put on the agenda the issue of hiring a town planner, without the ordinance, of course. Do we have to go through a public hearing again?
No.
Okay.
Not to hire a
No,
town
in fact,
planner.
you've already authorized.
Yeah, we've already authorized
the ad
and
and the
advertised.
hiring, and the only thing that's waiting for you is if the town administrator comes to you with a contract for your approval.
So, Mr. Tice, just so it's clear to me, the fact that we're in the hiring process is sufficient to you, the fact that we've authorized the hiring process is sufficient then at this point legally for the town to hire a town planner, in your opinion? Okay. Okay.
That was my thought from day one.
Let's go on.
All right,
Another public hearing.
thank you, Amy, it was a pleasure. Okay, continuing public hearing, continued from June 23rd on proposed changes to fees and fines resolution. Request to continue to August 25th. Well, that's an easy one, great. Okay, we've done that. Okay, appointments and resignations.
Wait a minute, you need a
Is
motion.
it?
Oh, we need a motion.
I move that we continue to the August
Looks like it.
25th.
We
Second.
have a motion and second. All those in favor? Opposed? Motion carries. Okay, appointments and resignations. A resignation of Leonard G. Schmidt from the Economic Development Commission effective July 31st, 2014. We have a letter from Mr. Schmidt, and he has been a key part of the EDC, and his input and his expertise, in my opinion, will be sorely missed. And with the council, I would that we send him a letter and accept his resignation with regret, and thank him for his service to the town of Tiverton.
So moved.
We have a motion, second. All those in favor?
I would just like to add that now I think with this resignation, there are at least 2 openings on the Economic Development Commission for any interested parties.
Their meeting just wanted to know.
Just one?
We already appointed one.
Yeah. Appointed one.
Oh, okay.
So we have one.
Yeah, I know.
We did appoint.
Oh, yes.
She's not yet.
Yep. Now we have the resignation of Susan T. Krumholtz from the zoning board effective September 1st. Again, accepting her resignation with deep regret. Please send her a letter thanking her, for her service to the town. And entertain a motion.
I move that we accept with regret and thanks the resignation of Sue Krumholtz from the Zoning Board of Appeals, effective September 1st.
Second.
Motion second. Any discussion? And all those in favor?
Aye.
Motion carries. Again, we now would have an open on the zoning board effective September 1st, so please, come on down. It's a fun department. Appointment of the harbor master, term expiring 12/31/14, Tyler Loomis, 89 John Dugan Road. Recommendation of Bruce Cox, Chair, Harbor and Coastal Waters Management Commission.
I assume he's doing well? Isn't this the interim?
That's the kid, yeah.
So,
I'll entertain a motion.
Sorry. So moved. I have a question.
second.
Okay, discussion?
Yeah, I just have a question.
Yeah. Oh, go ahead, Jim.
The question I was just going to ask is, did we have to post this position again, or have applicants?
No, you did. It was posted, there were numerous...
A while ago, right.
Yeah.
But
So-
this is the outcome of that. It took
Okay.
the Harbor Commission quite a long time to go through the finalists.
Yeah, I was just wondering how
I
that
mean,
works
while
out.
he was the interim. because
Right, I remember that.
he-
I just didn't know if we had to be if we had to repost this with the position being open again. I don't know.
Hey, Brett?
That was what I was going to ask.
Oh.
And he has now since turned 18, so he meets all of our requirements, right?
Yes.
State law provides that it's an annual appointment,
Okay.
so you're just appointing him to the end of the year, and then it'll come up again.
Here we have a motion second. All those in favor?
Aye.
Motion carries. Okay, where am I now? I just lost my place.
Administrator.
Got it. No, I know. Town Administrator, motion to reconsider fees for RV parking on beaches.
I know this has my name next to it, but I'm not a member of the council, so
All
I
right,
can't
that's-
make the motion.
That's me. I'm
Councilor
sorry.
Brett Pelletier.
Yeah, between the June 23rd meeting and about 45 seconds afterwards, some of us realized that we had made what I think is an incorrect, an unintended change to the fee schedule. And that was for residents, there was no specific heading for RVs and campers, I think it's RV camper and motorhome. It was just one line item. We took that to mean it was resident or non-resident, from what we understand from recreation and everybody who's ever gone to the beach with an RV. That was only for non-residents. Residents were allowed in with their regular resident sticker. As a matter of course, they issued them a resident sticker to an RV, regular RV. So what I'm suggesting is we reconsider the vote and make it clear that we are making those $25 and $35 per day parking fees for RVs for non-residents only.
And Brett, would that be 25 during the weekday and 35 on the weekend?
Correct, and holidays.
Okay,
yes.
and holidays.
Yeah. So I think if we do this, our task is twofold. We need to move to reconsider, and then we have to actually reconsider. So
Are you making that motion?
I move to reconsider the vote taken on June 23rd to charge residents $25 to park
Second.
their RVs on the weekday and $35 to park their RVs on the weekend and holidays at the beaches.
Second.
So this is just to rescind.
Yes, this is
Okay,
to reconsider
Just
that.
to change it to non-resident.
No, this
This
is
is
to
to
vote to consider that.
Bring it
right?
back,
Yeah,
undo it,
this is
and then
just
read
to-
it.
Oh, okay,
Yeah.
okay. So we
Right.
we have a motion and a second. Any discussion? And seeing none, all those in favor?
Aye.
No,
Now I would move that the parking fee for non-resident campers, RVs, and motorhomes be $25 per day during the week, $35 per day for weekends and holidays, and there be no charge for RVs, campers, and motorhomes for residents.
Second.
With sticker?
Well, yeah, you'd have to get a sticker.
To prove you're a resident.
Well, you're not clear. You say residents, so somebody can just grab their phone, you know.
You can't get on the beach without a sticker. It doesn't say it anywhere. You're required to get a sticker. You're not allowed on the beach without a sticker, ergo, in order to get your RV on the beach, you need a sticker. I will include it in the motion, but it's going to be the only one that says that.
All right, okay, that's fine.
Can we let this,
Okay, any discussion?
Yes.
Oh, I'm sorry.
Could I ask a question? What's the length of time that the RVs can be on the beach?
From open till closed.
Open till closed?
not overnight?
Not
I usually go down there after 5 o'clock, 4 o'clock, sometimes 6 o'clock, and have supper. And I was just, a long time ago, I suggested that the town consider allowing some, 2 or 3, like Little Compton has down there, to stay overnight. They acted as security guards in a way. And you might help your bottles and trash and stuff down there if you had somebody there that could call the police when there are parties at night. Just a consideration.
Dick, I wouldn't disagree, but I think the ordinance of the town related to beaches and public spaces is a little more forceful than this would be, and it holds more weight, and I believe that says that all beaches and parks close at sundown? Sunset.
There's a lot of
So-
people down there at night.
Yeah,
And either stop it or get, there's residents down there having cookouts and things after dark.
yeah. I don't
And
think
if you're going
we're,
to stop them, but
well, I don't think we're intending to,
I think you could make a little money by the same way Little Compton does. Have just 2 or 3 or 4 spaces down there that would be able to be rented out overnight and have some security people there to
I
call a
think-
policeman.
I think that's a good idea, and I think we ought to talk about that for next year, because we have, this is an annual kind of iteration, and I think a policy for beaches is going to be ongoing, anyway, so that's,
So we have a motion?
yes, and a second.
All those in favor? Opposed? Motion carries.
Thank you.
Councilor Shabbat, discussion and possible action on issues and concerns with zoning, commercial form-based code amendments as approved June 30, 2014.
I think it was just Teresa.
Okay. This could be a long discussion.
It's going to be a long discussion.
The critical items are E3A and E3I. For E3A, I have some issues with the public notification of the use table changes as was adopted in the commercial form-based code amendments as approved on June 30th. In reviewing,
Okay.
Maybe a decision's already.
Yeah, you'd have to make a motion.
A decision's
I mean-
already been made on
Yeah.
this, so doesn't
Well,
there have to be rescind and vote and then we discuss it?
the first thing, first of all, a motion to reconsider would have to be remade by someone who was on the prevailing
Right,
side.
before we discuss.
And second of all, with the zoning, you can't do that because the public hearing ended and you'd have to provide people a new notice. You'd have to go and spend another $6,000 and notify people if you were changing the ordinance that you've already changed. I mean, if you want to discuss future changes or something like that, but if you
But
want to
don't-
change what was specifically adopted, you can't.
No.
Right, so don't we have to, someone has to make a motion
From the
on
prevailing side.
Unless the prevailing side,
to
but
rediscuss it, and then we
then
go
you'd
out for
still, you couldn't
advertising.
act it. You'd
You
have
couldn't
to
act
Do it
it.
tonight.
That's correct.
We'd have to put it on a future agenda.
Yes.
But right now, someone from
Prevailing side.
the prevailing side would have to make a motion to go back into this discussion.
That's my understanding, since
That's
it
my
says
understanding
about
also.
Because it's already been,
Yeah, because you can't,
to reconsider, that's what the request is, to reconsider based on the issues. And I had concerns about a motion, an agenda item even being placed by someone who wasn't on the prevailing side, but I think that can go either way. But I think to go further, you do need a motion from
well,
someone
I
on the
think the
prevailing
agenda
side.
item is to reconsider the vote, and then someone from the prevailing side has to make the motion to do that. We can't have any discussion without that.
That would be correct.
so I will entertain a motion. Okay, seeing none, it goes no further. Nothing under financial business, new business, town administrator.
Mr. President, in early July, in an ongoing effort to keep lines of communication open, I sat down with the leadership, both local leadership and a state representative from AFSCME, to reconcile the new budget to their contract, because changes were made in some of the positions that they represent in Town Hall. Most of what is presented in item G1 represents all of that house cleaning cleanup. So to rectify the job titles to their rates of pay and where they stack up in terms of seniority. Section 3 of this MOU is the only new language, or the only, we'll call it policy language, if you will, which is that in the event that the canvassers clerk position were to be reduced or eliminated, then the position would revert to today's status quo, which is you'd have a full-time employee splitting their time between the clerk's office and the treasurer's office. As I outlined in my memo to you, going to advocate for that language, but I have no objection to it. I don't anticipate that the canvassing clerk in today's modern society would now be reduced or eliminated, given the burdens of complying with election law. The restoration would, if it did occur, the restoration would be to today's status quo, which is an operating model that has been in existence in Town Hall for some time. And the seniority rules would be preserved in that instance. So he would basically be bumping down. So with that in mind, I would ask the council to join the union in ratifying this language so we can clean up the contract.
I'll entertain a motion.
So moved.
Second.
We have a motion and second. Any discussion?
Can I just ask a clarifying question? So if we approve this tonight, Matt, that gives you the authority to sign on behalf of the town, which it looks like it's a three-way MOU.
Yeah, this is basically a TA, tentative agreement.
Okay.
And you'd be ratifying what I've already agreed to.
Okay.
As tentatively.
Okay, thank you.
Okay.
Is there any impact statement needed for this?
No, when we put the position forward, there is actually no impact because we're making a combined position, a full position. And the impact will be when the contract comes forward for a part-time treasurer's billing, but this just doesn't have any.
Okay.
It's a
Thank you.
full-time
It's taking
position.
two parts
Was
and
done
making one whole.
in-house.
Yeah.
Yep.
Okay. Anything else from the council? Okay, we have a motion and second. All those in favor?
Aye.
Motion carries. Okay, Mr. Wojcik. Oh, Steve here?
No, Steve's away on vacation.
I thought he could only take vacations on the 13th month of the year.
He claims this is the first Monday he's missed in 7 years.
I'm sure we can
I should dig one up.
prove that.
He's requesting the council's permission to advertise to hire a half-time mechanics helper, which my understanding is that was provided for in the budget. He's
Yes, it's
looking
in
to
the budget.
advertise.
So moved.
I have a quick question.
We have a second.
Second.
first.
I have a
Okay.
quick question.
Discussion?
The first general purpose line, it says, perform semi-skilled work in maintaining the vehicles and mechanical equipment of the department. Does that provide any liability to us? Because we often have these folks work on equipment and vehicles not specifically DPW, but fire trucks and other pumps, I'm sure, or some kind of, there's got to be some equipment that we have them work on.
Yeah, they've crossed.
Yeah, and I know they work on some of the heavy trucks for the fire department.
Could we change it to within the town?
I just don't want to, I mean, it might be nitpicking, but
Matt, could we change it that way?
I'm just looking to see what we advertised. That's easy enough to change. Under general purpose.
Yeah.
Mechanical equipment of the department to mechanical equipment of the town.
I would respectfully request the motion to be amended to include the amended language.
Second?
I didn't make that motion, Bill did, so.
I made the motion.
You made the motion?
Right.
I'm sorry.
Denise made the motion, you seconded it.
So amended.
Thank you, sorry.
Okay, you'll second the amended.
Don't take offense to that, Bill. Or Denise.
You can call me Bill anytime.
Who were you before?
Renee, I'm
Renee.
sorry. I don't know who Renee is.
Half-time,
I would-
hours with benefits. Is that how are you defining half-time?
Oh, yeah, I think that's my question also. If it's 20 hours, we're paying benefits, so if it's 19, we're not.
What did we put it in the budget as?
Where does that?
19.
Whatever it's in the budget.
Nancy said it's at 19, I don't really recall.
No, he just called it a half-time.
It just said
position.
half-time,
it
It
didn't-
came before the budget, that's why
So we'll change it to 19 hours, is that what
it
you
could be
said?
19 and a half. Isn't anything over 19 and a half, you have to pay benefits?
Right.
Do you really?
Yeah.
Remember, we got into the...
Yeah.
Yes.
Why don't we just call it 19?
Yeah, so hiring new halftime at 19 and a half hours?
So I needed.
Looking
so
for the
Bill needs to make
advertisement
another
again.
motion.
Short of benefits.
sorry?
Why don't we call it 19? Is it 19 and a half?
Doesn't say. Make it 19, so.
Well, I mean, the request says 20 hours per week.
We have to change it.
So I'll accept a motion to change the hiring of a new half-time, 19 hours per week employee.
So moved, I'll change my motion once again. Bill?
Okay, we have a motion. Do we have a second?
So we're at 19 hours
Yep.
per week. Rachel?
You want a second?
Renee?
Do we have a second?
That doesn't really matter. Yes, I will second.
Okay. Any discussion? Seeing none? All those in favor? Opposed? Motion carries. Okay, solicitor. Yes, historian, good, move along.
I'm sorry? Actually, I would like a motion to add an item to the agenda for information purposes only regarding Town of Tiverton versus James Pelletier and Melissa Pelletier.
You've got an item in new business.
Oh, I'm sorry.
Historian.
I'm sorry.
I know, we've all kind of lost it.
Dropped, okay. This is dropping there, okay. This is really, sure, you talk about it.
This is kind of done at my request. This is to create a position of a historian. Because if the council approves this, we will come back at the next meeting and ask for an appointment to that position. And part of it is because we have someone that does a tremendous amount of work in this field, but is not an elector of the town. So you can see that the resolution gives it an ex officio appointment with non-voting, but we don't want to lose that person. She has done tremendous work in record keeping in this town and in archiving, in cemetery commissions and everything. So we thought this might do a little bit of tribute to the person that has been doing it. And it's a good position to have for someone else who wants to serve as historian.
I think it's wonderful.
I do too. I think it's great.
Yeah, all right. I will move that we adopt the resolution creating a town historian
Second.
as drafted.
We have a motion and a second. Any discussion? All those in favor?
That's good.
No, we're not even there yet. We're not even there yet. Okay, we have no bids and requests. Okay, town administrator, items and announcements.
By way of announcement, I only want to draw attention to a couple of things that were said earlier about planner position. There's a lot of things that this town doesn't have, including things like personnel director. We don't have anybody who does personnel. You don't have a budget officer. Town administrator is your budget officer, drafts the first cut of the budget. So what we've been doing over the past week on that personnel director front is working with our vendor for HR services, which those transfers that were done at the last council meeting on June 30th were to fund the effort to get a professional consulting firm that we already have a relationship with to help us build an HR function that is defensible on many different scores. So we've met with them, and we're establishing a work plan. We're going to be establishing an audit, an HR audit of all of our files, of our training requirements, and all of the rest of the things that go with being an employee of this town without creating liability for the town, protecting the town to the greatest possible extent. That work, I just want to announce, has already begun, and it will be ongoing. It's tremendously time-consuming, but I think it's going to be a necessary part of building the systems of the town to be competitive in today's atmosphere. Nothing else.
Thank you. Council announcements, comments, or questions?
I have a couple of things. I just want to remind everybody that August 24th will be Matt's 6-month anniversary with us, and we,
There is no party.
no, but we are under agreement, we ought to reevaluate him. So I just thought that we should start thinking about how we want to do it, if we want to use the same tools that we've been using. I also want to say that I've asked Matt that, starting August 1st, that the council gets a documentation of all the overtime use in town, and the justification for that overtime, so that we can start keeping track of that. Because it seemed like budget session, we were told about all this overtime, and we could not do anything about it at that time. So I just figure if we look at it from August 1st on, justification of the overtime, and maybe we could think of some creative ways to not have that overtime. And then it makes the department heads conscious of it also, that we're looking at it, and they may be able to look at it also. I just thought, and I asked them to put it on the consent agenda, and if any of us wanted to pull it out, we could.
I just have one thing, and I'll be very quick. I know it's very late, but I've got numerous calls about this. It was about the tax bills. I got a lot of complaints about
Them being late.
and I actually have a few people actually call me who received their tax bill on July 11th, postmarked July 10th, and they came in to pay their taxes. They're like, I just got this bill on the 11th. How can I not pay it late? And they were told it is the responsibility of the tax payer to know when to pay the taxes and so on and so forth. So if that's true, then why do we even bother invoicing any of the bills?
No.
No.
So-
I don't think that was.
That's what was conveyed to me. This person is someone, I know is someone who does not like to pay things late, and they were already emotionally distressed because they were already late before they even began. So that was just one instance that I received, actually very recent, that's just today, because of the lateness of the bill. And there was, quite a few others also, not as extreme as they received the bill on the 11th, but still, they only had a couple days, and they worked full-time, and how can they get down to town hall, and it's during lunch, and oh my God, so all those things.
I have 3 items. Oh,
Well,
you want an answer on that?
Well, I'll do the best I can. I was afraid that was going to happen. I was assured that when the tax bills were late, but they were still going to be delivered by Vision to the post office on July 1st or 2nd, that we were giving people ample opportunity to pay the bill on time. We made accommodations here, so additional staff manned additional windows. They stayed open through lunchtime. We did the best we could to manage parking. The notion that this vendor couldn't get the bills postmarked until July 10th. I don't know that the administration has the discretion to waive things. It might be a little overly picayune. I think people should not be charged a late fee if the postmark says the 10th. There's a mailbox rule. You can't pay something that you haven't received yet. But I'm happy to be a little bit more aggressive about this. I'm going to have a discussion with Vision about docking what we pay them. We've paid them for a faulty service. It's absolutely ridiculous.
We shouldn't
in
be
this day
paying
and
them
age.
for not delivering, exactly.
So they failed to deliver the bills on time, and then they misled the town's administration as to when they were actually going to get everything out.
Yeah,
And that
and we're the
is-
ones
if
that
they
have to listen
weren't-
to that, not them.
If they weren't a monopoly, we'd throw them out on their rear ends. But unfortunately, we have a long-term relationship. They're deeply embedded in our software management systems here. So the best we can do is say, there's no way you can charge us full price for the level of service you delivered us. And I don't think anybody coming in, I would hope they'd come in with the envelope so they can show the postmark. But unless the solicitor tells me different, if somebody comes in this week with a bill postmarked that late, I don't think we should be assessing them any fees.
The state law does not give anybody the authority to waive the fees in the office on the administrative level. Because you can imagine the abuses that would happen and have happened, you know, at Providence, you know, where certain people got charged late fees and certain people didn't. So what you could do, though, I think, is you could put it on the agenda for the next meeting or the next meeting after, since we got the big public hearing on next week, but the regular meeting on the 28th, to refund people, you know, if anybody paid it, you know, pick a certain period of time. You have the authority to require, to refund it if they did it, and, you know, I think that, Matt, gives you a good number to tell Vision, you know, I don't know that it's gonna be that much money overall, but they should be reimbursing the town for what you refund people that you, they pay the interest, if it was a couple of days' interest.
I would strongly recommend that whenever the contract comes up for discussion again, that we give strong consideration to performance guarantees to cover us in the future, in case any of that sort of situation happens again.
If you will, an incentive-laden deal, like they have in the sports world.
When can the treasurer's office, or no, actually the tax collection office, let us know how many people paid late fees, or the dollar amount?
We have to set it.
They would have only begun paying late fees on the 11th, and even if it was in the night box, they wouldn't have paid a late fee then. If it was postmarked by the 10th, even after, if they notice it postmarked by the 10th, I mean, the check coming into the town, they won't charge interest on that either. But we have gone through this before. We've actually even had delayed payments before.
Yeah.
But as a tax collector, we have letters from the Attorney General, so no, I do not believe they can do anything about it, but the council could. So,
Perhaps the tax collector and
could notify,
could come up with a
Yeah.
window of time that seems appropriate.
oh, her system will run off everybody who's got interest.
No,
Well,
but I'm
we need
just
a-
saying,
we need an
as
end
a
date.
date certain, to say anybody who didn't pay.
Well, the bill was due July 1, and you gave them grace until July 10th.
Yes.
They got it on the 10th, give them a grace until the 19th or the 20th. It's the same grace period.
Extend the 10
Yeah, that's what I'm
days.
saying, so that we have a date certain, so that you
Well,
can
if
say
I were the
up to-
tax collector, I would tell you shortly, I would end that, because it's a bad precedent to do, because next year, people are going to come in, and they're going to pay on the 13th again, or the 15th again, and say, I did that last year and didn't get charged.
No, they have to show that.
I know,
Yeah.
but we've done it, and that's what happens, yeah.
It's postmarked.
But if you're going to go to the 20th, just inform, I'll put it on the next agenda.
No, I was, I
Oh,
mean, that's
The
not
next
a date.
agenda isn't till the 28th, so you really can't take any action until the 28th.
Right.
But it could be as of the 20th. Yeah, I wouldn't go past that.
Yeah. You know, and again, obviously, it's proof. I mean, if somebody, you know, we know they got theirs on the 1st, just to use that as a date, and they're coming in saying, oh, well, I didn't pay it till the 15th.
She probably should just document the one she has like that,
Yes.
because you could have got your bill on the 2nd and be paying late. There are
But they
people that pay
need to
late.
show documentation.
Yeah, so it won't be that many.
Yeah, so just as long as they have the documentation to show that they're late. Okay?
All right, Mr. Shabbat.
Yes, I just have 3 announcements. A reminder that this weekend, we have the South Coast Artists 11th Annual Open Studio Tour, July 19th through the 20th, and a map is available at the Town Hall or at their website. Also, the Arts Council invites you to a reception on July 25th, Friday, July 25th, from 6 to 8 p.m. at the Town Hall to review the artwork of 3 artists, their photographic displays of Rick Barrett, David Robert, and John Lincourt. And the last item is there's a free Native Arts Festival down at the Tiverton Four Corners Arts Center, July 26th and 27th, from 10 a.m. to 5 p.m. That's it for me.
I would just remind people that Friday, Saturday, and Saturday of this week are the planning charrettes for Stonebridge Reimagines. Friday, 2 sessions. One starts at 10 a.m. at the Fort Barton School, and then the other one starts at 6 p.m., right?
Right.
And then on Saturday, again at 10, I think it's at 10, right, Kate? 10 on Saturday? 9 or 10, show up early, get good coffee and
I
donuts.
think it's 9.
9 o'clock, and also 9 to 2. So if anybody's interested in Stonebridge Reimagined, there's also a survey online, there's a website, there's some flyers in the back of the room.
And also as a reminder, Tiverton Celebrates is the 25th, 26th, and 27th. The 25th is the bonfire and concert down at the beach. The 26th is the parade and events at Sandy Woods. And the 27th is the relay and the kayak. All right. And there's also flyers available for that, I believe. And it's on the website.
Hey, Town Solicitor.
Thank you. Could I'll try to be quick, but if I could ask for a motion to add to the agenda, just for information purposes, Town of Tiverton versus James Pelletier, Melissa Pelletier.
So moved. Second.
We have a motion and second. All those in favor?
Aye.
Aye.
I just want you to know this is down for a sentencing hearing on Wednesday morning before Judge Thunberg. But I did receive a fax from Pelletier's attorney, Michael Kelly, this afternoon. They sent a letter to Judge Thunberg, and she's apparently got a jury trial going forward. When they brought that to the attention, they say, "Your clerk informed our assistant that this matter may be pushed to Judge Rogers for sentencing. We respectfully request that this sentencing in this matter be heard by you, since you have been involved in this matter all along and are most familiar with the facts and circumstances concerning the case. We are available on another date in lieu of July 16th if this would be more convenient for you." So one is the fact that actually I and Assistant Solicitor DeCenzo agree that we would like to keep the sentencing before Judge Thunberg. She's the one that's heard the entire trial. That's what's taken so long. We've been at it for so long, we don't want to have to go educate a new judge at this point in time, so we certainly concur in that. Obviously, we'd like it heard as soon as possible, but I want people to know it may be postponed. So if anyone has a question, is planning to attend and wants to know, check in with me late tomorrow afternoon, in case it is changed. Sure.
Okay.
Next item, K1, Eagleville Road Realty. This is just the answer to the appeal as filed, the appeal from the zoning board, sitting as the Board of Appeal. And this is the answer that we filed for your information.
Okay.
Any questions?
Yeah, if I had the appeal, I'd know what the answers responded to.
It's not,
It is. I saw
it's
it.
there, K1. Oh, you mean the complaint?
Yes.
That was given to you a couple of weeks ago.
I know, but when you just look at it, admits allegation,
Okay, all right, well,
you know.
sorry.
It's fine.
Then you'll find K2 is equally exciting, is the answer to the case that we had, that you'd also received a couple of weeks ago, Ernest Cordero. He's the one who had the claim that was illegal, that his property was sold at tax sale, and even though the state notice requirements were complied with, that they weren't constitutional. So we fired an answer. The actual interesting ones there are there in paragraphs 28 and 32. It's the same thing, but basically his complaint's full of things saying, I never knew of any of these things would happen to me. You didn't tell me afterwards that my property was sold, and it's clear actually the town did in fact notify him before that it'd be sold and gave him the statutory notice telling him all about redemption, that he could lose the property if he didn't redeem it. So. Next is K3 A and B. This is Secana River Bridge tolls. This is filing from the town of Portsmouth, requesting basically restitution of the tolls that were paid, and from that, award of legal fees and costs. As you know, the town of Tiverton has moved to intervene, which motion the judge has never ruled on, neither approved nor denied, and that's actually one of the things that I'd like to talk to you about in executive session. But publicly, this is what was filed so far. That's it for me.
Okay, Town Clerk.
Only that all the declaration papers have been now checked, and the Board of Canvass will finish certifying them tomorrow morning.
Yeah, did you get mine?
Oh, I'm sorry, nomination papers. And for those of you that didn't submit them,
Okay, I will entertain a motion, Mr. Lambert.
I move that we go into closed executive session pursuant to Rhode Island General Law 42465A2, potential litigation, and 42465A4, investigation, Ray Fire Department.
Second.
We have a motion, second, all those in favor?
And stay in closed executive session pursuant to Rhode Island General Law 42465A2, Ray Litigation, Site Ready, LAL Construction, Inc. et al.
Second.
Motion, second, all those in favor?
And stay in closed executive session pursuant to Rhode Island General Law 42465A2, Ray Litigation, Secana Bridge Tolls.
Second.
Motion, second, all those in favor?
And stay in executive session, closed executive session pursuant to Rhode Island General Law 42465A2, Ray Potential Litigation, Pension Reform.
Second.
Motion, second, all those in